Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people? The people is misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. Glad you could make the jump over. We are back. The jury is out on a brief potty break. A very brief potty break as we are about to continue with closing arguments. State has concluded their lengthy but very thorough summation of everything Linda Stermer has said about the events of that day to everyone that we could find. Every comment spelled out in painstaking, well, it's just pain on a PowerPoint. PowerPoints are always pain. It was painful, but it was a lot to go through, and it spelled it out. And they never once said the word liar. But that's what everyone who heard the presentation was thinking. We're going to be jumping back to court now. It is judges away from the bench, but the one thing they didn't say is the thing that got them into trouble the first time around. That was that she is a lying liar who lies. And that did not come in this time. Every word but liar. So I object anytime a PowerPoint is used. I can count on one hand the number of times I've seen an effective use of a PowerPoint in a courtroom setting. I'd like to say I can count on one finger, but you know which one that's going to be, and that's not appropriate. So we are coming back to court here. Yeah, calling her a liar got her 8 years of freedom. Well, before we get going too far, we have to say hello. Welcome, Kimar. Thank you for welcoming us into the new live stream. You were here first before anyone else. You talked, you said hi. It was quiet until then. We're going to punish you for your good deed. We're sentencing you to internet ownership for the rest of the day. Lee Bell is happy just that all her appendages made it through the portal. If you ever watched Galaxy Quest, that is a legitimate concern. Things can happen. I guess that also happens in maybe Spaceballs. But, there's things happen in portals. You've got to be super, super careful. Let's see. Are the seats not working? I'm thinking maybe. Oh, looks like the seats are working. Birdie, the evidence will show B. I love the evidence will show. I can guess where you got that statement. All right. Boom. All right. I think we're coming back here. So we've got just a few minutes. What were your impressions of? We only got one new word, easily. What were your impressions of the state's closing? Other than the fact that it was long. I know it was long, but we've got a couple people here that are brand new, that literally have not been following the case, that jumped in because they're waiting for another case they're following or something to happen. They got on a little early. This is happening. They checked in and they're like, whoa, this is a little much, right? She's told this story 3 times now, and she's still going. It was long. But Linda said so many different things to so many different people. I don't know how she could have done it any better, because she did not give the defense anything to attack other than Linda's own statements. She literally just teed them up for the only thing they can say is, look, we get it, jury. We get it. She's a liar. And that's the thing they don't want to say or to have the state say. So the only thing I think the state's going to be able to attack is the conclusions, the circumstantial evidence. They want to say other things could have happened. Look at the fire. It could have happened there. We don't know that it happened 20 foot by 20 foot. That's a big area. They want to introduce doubt as best they can. There's a lot of circumstantial evidence that they have to introduce doubt about each part because a lot of it adds up to a great sum. Very great sum. I stood nodding at my drying rack. Yep. Best closing ever, says Tower Hill Girl. Thought she covered all the bases. I think her delivery speed was great. It was painful for those who had her on like a higher speed because you were catching up. And then when you slow down, that got painful. But I think if anything, I think she lessened some of the deliberation time for the jury. Loved her reading each individual story. I like the 3x5 cards, Curly Q. I loved that she had the 3x5 cards, and she's like, here's a stack from this date, here's a stack from this date, and she's flipping through the cards. It was great. A 3x5 is fantastic. It's a great speaking tool because it's too small to stay focused on while you're talking. Right? You can't just look at the 3x5 card. There's too much peripheral going on. It forces you to look at the listener a little bit. But she had a great delivery. Could have been half as long. I agree. But arguably, Cody, Linda could have told half as many stories, and that would have fixed that problem. What other appeals does she have left? Please, she has all the appeals left because she is not convicted. You only get appeals if you get convicted. And when the appeal was granted, she get a new trial. It's as if it's her first trial again. So if she's convicted, she has all the appeals she wants. This is not an extenuation of the first trial. It's a complete redo for that. If she's not convicted, she walks free as she is today. She doesn't need the big yellow pad. I cannot wait for the big yellow pad. I hope he got a big fat marker. Like a big old Sharpie 1-inch XL size industrial marker that smells really strongly, that everyone can smell in the courtroom, that makes the squeaky noise when you write on the paper. I hope he got one of those because this is his time. He's wanted to use this pad all trial long. Love the way the prosecutor weaved Linda's statements into the facts of the case. It was masterful. It was as if Linda told stories like they wouldn't come back to her, right? She was telling stories to different people to get them to be quiet about different things. But then all of the people got together through the investigation, and the stories all confront each other. Which way do you think the second trial will be different from the first one, the KR case? Please explain. Dog Lover will probably focus on that more when we get there. But obviously, just a few little ones, some of what the state is allowed to go into and who they're going to accuse as a possible third-party culprit is different. I think the state would be smart to do a very different approach instead of trying to prove who didn't do it. Focus more on who did. I just think I think it'll be different. I think it'll be different. Yes, Rhonda, we will. Oh my gosh, I need a squeaky marker. Yes, everyone can hear the squeaky marker now in your head. That's a gift from me. Thank you. You're welcome. Chat isn't on screen. Fixed it. Thank you very much, Shaylin. Any news on the jury? I think they had 15 yesterday. They're going for, 16? 12 plus 4. All right. Yep, here we go. Got people walking in. That looked a lot like Thommy. Like tons like Thommy. You see that guy? Let me go back on the replay. Oh, you guys can't see replay. I'm not connected right. Let's see, does that fix it? Yeah, I think so. Can't see why that's not working. Weird things happening. Sent the marker needed to mod chat. It's gonna be a big fat fatty. A Magnum marker, Sharpie Magnum. Let me see if I can find this for you so I can share this with you.
In front of the Walmart.
Okay, counsel, we're back on the record. Any matters to address before we bring the jury back in?
None, Your Honor.
None, Your Honor.
Thank you. We'll bring in the jury.
You will bring the jury. I can't find a good link to this one that I can show that shows the size. I need it in somebody's fist is what I'm looking for. Let's see. Oh, there we go. This will work.
Bring the jury.
We'll bring the jury in just a second. Jury's coming in.
Are we going to address subject matter jurisdiction?
Welcome back. Mr. Mueller, closing argument.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. This is our last time to speak with you. The prosecution has the burden of proof. We'll go into that, but that's why they get, in a case like this, the last say. This is the only time, that I get to speak to you. I want to thank you on behalf of Linda Stermer and our team for the attention you paid
Her boyfriend.
throughout this case. Everybody took notes and asked question after question after question. So I know you're paying attention, so thank you. I want to tell you a little bit about your job. When you go back to the jury room, you actually have 3 jobs back there. One, obviously, is to decide the facts of the case and how they apply to the law. The second job you have is to make sure that everybody on this jury follows the law. And when I say follow the law, when you were sworn in and we selected the jury, a lot of questions about the presumption of innocence, the burden of proof. As Linda Stermer sits here today, she is innocent. As Linda Stermer, when you go back into the room, when you walk through those doors, she is innocent. That is
It's
a
when you come
solemn
out
oath
that
you
it
took
changes.
to hold that throughout this case. The third job you have, when you go back there, is to explain your position to the 11 other people on the jury. How you saw the evidence, what you thought about, how you considered it. And to also listen to them fairly and make sure that everybody gets their word. When you follow the law, what I'm saying is you have a right as a juror to make sure that when you go home after this case, everybody followed the law. Nobody bullied anybody else into trying to cave their opinion without following the law about presumption of innocence and the high burden of proof beyond a reasonable doubt. You heard Ms. Zuderveen speak for an hour and a half, and I timed it. She spent 5 minutes on the fire and the cause of the fire. So let me tell you what this case is not about. This case is not about a van impact. You heard Dr. Markey on the witness stand. Dr. Markey and Ms. Zuderveen said what she thought Dr. Markey told you. The one thing that Judge Brickley will tell you is what we say here is not evidence. what you heard from the witness stand, that's evidence. That's what you consider. And I'm sure Ms. Levine didn't intend to misrepresent anything, but she didn't have a transcript of his testimony like I do, like we purchased. So I want to tell you what Dr. Markey said in terms of the cause of death. On page 19, Dr. Markey said to a question, my question, well, let me just kind of summarize and make sure we're clear before I leave you. The van impact had no connection with the death. The death was caused by thermal burn injuries. Fair? Said, yes, I believe his death was caused by the thermal injury. Dr. Markey's opinion is the official medical opinion in this case. It's undisputed. And the government, the state, with all its resources, couldn't find another doctor in the state or in the country to say that the van impact had anything to do with Todd Stermer's death. It was solely caused by the fire. And Linda Stermer has not been charged in this case with anything having to do with a vehicle impact to Todd Stermer, not even a misdemeanor. So what does that tell us? One, the van didn't cause the death, and the van certainly didn't start the fire. Why did they spend so much time on the van? Well, I'll tell you. Because they wanted to distract you from the fact that they have no evidence of how the fire started. This case, ladies and gentlemen, the charges are first-degree premeditated murder. Ms. Levine showed you the jury instruction, went through a whole bullet PowerPoint. Boiled down to, Ms. Stermer intended to kill her husband, thought about it for some time, and then carried it out. But the carried it out part is she's charged with felony murder. The felony is arson. So if there's no arson, there is no crime. If there is no crime, there is no premeditation. And so when you consider what you need to do is look at two things. Was the fire intentionally set? And if it was, did Linda Stermer set the fire? Those are the simple issues in this case. The burden of proof for the state is extremely high. Let's talk about that. Burden of proof is beyond a reasonable doubt. Reasonable doubt, ladies and gentlemen, simple terms, is doubt based on reason and common sense. If you have any doubt, as you look at all the evidence today that I'm going to show you and summarize the evidence, if you have any doubt that doesn't require you to abandon reason,
do they tape the
then
edges
that's reasonable doubt.
to cover the compass?
And what is a doubt? Well, remember I explained it with Mr. Leroy. To lack confidence in, to not trust. That's doubt. Here's the burden of proof, ladies and gentlemen.
Oh my goodness,
In a criminal case, the burden of proof
We'll have to pan down
beyond
to see it
reasonable
all.
doubt is the highest burden we have in any kind of case. And the reason is because when the government is going to take your freedom, our founding fathers made sure that they couldn't just say, we don't like you, we think you're guilty, and we're going to put you in prison. So what do we do here? Let's look at this. Is there a slight amount of guilt? Not good enough. Is she possibly guilty? Did she possibly set the fire? Somebody says that, you say not good enough. I've done a lot of civil cases where people sue for money, car accidents, product liability. In a civil case, the burden of proof is a preponderance of the evidence. Is it more likely than not that we believe Wolf's side or the other side? kind of people like to say 51% versus 49. If it's 51%, more likely than not, then plaintiff prevails. That's not this case. Is it probable? Somebody says, I'm pretty sure, I think she probably did it. Not good enough. So when we talk about, as you go back into the jury room, what your lens is, these are the burdens, the things you need to consider. Very probable. I think almost for sure she did it. Not good enough. And here's the other thing. In a civil case, the highest burden we have in a civil case is called clear and convincing evidence. That's not good enough. What does that mean? So when you go and address each other in the jury room, clear and convincing evidence under the law
There's the coffee spoon.
is to be clear and convincing. The evidence must be strong enough to cause you to have a clear and firm belief that the proposition is true.
Maybe it's not coffee spill. Maybe it's fire damage.
Enough. Somebody tells you in the jury room, I really feel she set the fire intentionally. Not good enough. If you have any doubt as you look at the evidence that is supported by reason and common sense, no matter how small, that's reasonable doubt. And your job as a jury is to return a not guilty verdict unless the government, unless the state meets that high burden, exceeds beyond a reasonable doubt. Your job as you go in there, unless they do that, is to return a not guilty verdict. The other presumption, so the presumption of innocence, Your Honor will review the law, and the law says this.
The scale was so off on that graph. It was terrible. More likely than not, should be 51%.
We start out
oh, there's the spill.
With the presumption that where there's a fire, the law assumes that it had a natural or accidental cause. The prosecutor must overcome this assumption and prove beyond a reasonable doubt that the fire was intentionally set. You start with the presumption that's an accident. So that's the lens you need to look at as you go through this case. You know, before we started, one of the jurors asked, why would this case take 3 weeks? Should it maybe take 2 weeks? Because after all, it is only an arson case. Todd Stermer died of a fire. So you just have to decide whether the fire was intentional, and if it was, 2 issues, did Linda Stermer intentionally set the fire? Instead, what you heard, and I counted the witnesses, 20 witnesses over 1 week to talk about the van, to talk about infidelity, to talk about other issues. And why? Because the state wanted to distract you from your job, which is simply to decide, was this an intentionally set fire?
Say detract, distract.
And it's interesting. In opening statement, and I had that, everybody took good notes, I'm sure, so you'll be able to go back to opening statement. The prosecutor never said what caused the fire. And here, after 3 weeks, Ms. Zudovine spoke for an hour and a half and spoke for 5 minutes on the fire. And the best is say that Scott Leroy said the fire was consistent with being intentional. You don't get a conviction based on it would be consistent with being intentional. Experts, as we'll talk about, are held to high standards. There's no guesswork in experts. You don't get to speculate. We'll talk about speculative opinions that Mr. Leroy had and possibilities. You heard from every legitimate expert in this case, starting with the MSP chemist, Troy Ernst. We don't engage in speculation. Speculation masqueraded as an expert opinion is misleading. So that's why we don't do that. Your decision must be based on the evidence. The evidence that is clear, credible, and compelling factual evidence, not speculation and guesswork. So when you deliberate, you start with the assumption and the question, assuming Linda Stermer did not set this fire. Did the prosecution meet its burden of proof beyond a reasonable doubt for every fact it needs to prove to meet those elements, those boxes that she talked about? And if they can't rule out reasonable doubt, if they can't rule out alternate causes, if they can't rule out alternate theories, if you can't rule it out, that's reasonable doubt. And we'll talk about that as we go through this. It's got to be based on the evidence. You know, one thing we heard when you were being selected, and you'll remember this, Ms. Zuderveen, when she was asking you questions, asked you this. It might take, to present all the evidence, we might be here for 2 months. So will you give us a pass? Will you not hold it against us if we don't give you all the evidence? You're darn right you have to hold it against them. They have the burden of proof of bringing all the evidence they have to establish guilt beyond a reasonable doubt. They don't get a pass, and you can't give them a pass because they didn't bring you evidence. We'll talk specifically, but I do remember one thing I wanted to bring to mind. There was that video, remember Deputy Gruss did the in-car video, and they showed 10 pictures over 9 seconds. One of the critical issues in this case, as you remember, is how fast was the fire, the speed of the fire, the direction of the fire. 10 stills over 9 seconds. I asked Deputy Gruss, what happened to your video? I don't know. Don't you think it might be better, since we're talking about speed of fire and direction, if we had the video? Would that help? Yeah, that would help. But they didn't have it. So they can't help you with a critical decision in terms of the speed and propagation of the fire. So when you think about evidence that they say they don't want to show, that they don't have to show, can you give us a pass? Don't hold it against us. You hold it against them. So why is Linda here? Why is Linda Stermer, after 18 years sitting in the defense seat? Well, how about there was a house fire, and as soon as the police got there was a man who died, and then there was blood on a bumper. So they rushed to judgment and automatically assumed someone's dead, someone's alive, blood on the bumper, has to be a crime. And you remember Sergeant Leroy, when he arrived on the scene, spent a lot of time telling you about the pictures he took about the bumper, because he suspected it was a crime. He took more pictures that night of the vehicle than he took of the house. He is the state's origin and cause expert. This became a rush to judgment with no evidence. In fact, what it really was, as you will see, this was a prosecution looking for a crime, because they worked backwards. Why do you think Ms. Zuderveen spent the majority of her time this afternoon, and the majority of the case, talking about infidelity, talking about having romance and best sex ever, and wanted to run away? Nobody said she wanted to run away with somebody. Chris Williams didn't say that. You can look at your notes. No, they wanted to show you the why, the motive. Remember, she said, we don't have to show you motive, but they spent the whole case and the whole afternoon talking about motive. Because they wanted to show you the why, so you wouldn't focus on, how about the where? How about the area of origin? And more importantly, how about the how? Because they can't tell you how the fire started. Sergeant Leroy, when you go through your notes, and I'll summarize it, you will not find anything where he said he could identify the cause of the fire, how the fire started. And if you can't identify the how, and even the where, then you certainly can't identify the who. This was a prosecution looking for a crime, working backwards. And all because they found blood on the bumper. Ms. Stermer, from pretty much the first night, within a couple hours, had a target on her back, a bullseye on her back. She's grieving the loss of her husband and they make her take her clothes off to give it to them for evidence within 2 hours. Her husband's still there. Remember, you saw the pictures from Sergeant Leroy. He's there at 7 o'clock at night taking pictures of the body. She has to take her clothes off and switch clothes. She had a target on her back, a bullseye on her back, only because there was blood on the bumper, and as Sergeant Leroy said, time of day and 2 able-bodied people, and only one of them survived. And we'll talk about that is no kind of scientific evidence. We're going to talk about the scientific method in a bit. But I want to tell you about one thing. As you look and listen to Ms. Zuderveen, one of the things that she was talking about motive was the idea of they were in debt and she had a financial motive and she wanted to get money so they could clear the debts and whatever. Remember what Attorney Wilson said, who interrogated Linda Stermer for 2 days? After his investigation, he's a 30-year lawyer, doing nothing but exams under oath, trying to detect fraud. What did he say? And your notes will say this: there was no financial motive. I looked. There was no financial motive. There was no romantic motive. So when you think about what's been said here, it's all about credibility. We lawyers, we hope we have credibility. We hope what I tell you is backed up by your notes and the evidence. But what Ms. Zuderveen told you about a financial motive was completely opposite from what the witness said. It certainly wasn't about romance and sex. Now let's talk a little bit about what Sergeant Leroy did, because we're going to talk about the fire investigation. Remember, we talked about the scientific method. You probably learned more about the scientific method if you're not into science than you ever wanted to. I used to be an engineer, and sometimes it makes my eyes glass. You have to collect the data. Most important step. This is always for these fire guys: figure out the origin of the cause. So it really starts with step 1 here. Collect the data, all the available data that you can that might be relevant to the task. Even Sergeant Leroy said that. All the available data. Remember, witness statements, building records, we'll talk about those, physical inspection, excavation. Collecting data includes excavation of the property. That's where the gold is. That's where the evidence is. That's where you find the burn patterns and the objects that show you where the fire started and what could have caused the fire. Sergeant Leroy, under oath, and he admitted this, remember this? If you don't collect the data, you can't analyze it. You have nothing to analyze, which means you can't develop a hypothesis, which means you can't test anything because you don't have that, and you can't select a final hypothesis. If you don't do every single step, what did he tell you? You have an unreliable methodology. And if you have an unreliable methodology, what did he tell you? You have an unreliable opinion. It can't be relied upon. It can't be trusted. The very definition of doubt. Garbage in equals garbage out. So we're going to talk about all the various things he did and whether it complied with the scientific method like he said he did, or this guidebook which every single fire investigator trains to, tests to, and teaches to. NFPA 921. There were some questions about this is the 2024 version. It's been going on every 3 years since 1992. But the main thrust is you have to comply with the scientific method. The scientific method has been around in the sciences for decades. And so the fact that this was 2007, we're in trial in 2025. The 2024 version is what is in effect, what you have to comply with. And you might say, well, why are you holding the guy to 2024 when it happened in 2007? Because you have to be open to change your opinion based on new developments. And in this case, there are no new developments. It's the scientific method. Collect the data. Follow the steps. That's fundamental. Was fundamental in 2007. Was fundamental in 1992, and has been fundamental for decades before that. The scientific method. So let's look at what Sergeant Leroy did.
That's confusing.
Sergeant Leroy got to the scene on the 8th, and then under oath, he told you he went through the building and he cleared with his friend Greg Stormzan, who you heard from yesterday, an area 20 feet by 20 feet by 2 feet.
Tape measure.
800 cubic feet of debris. And what does that debris look like?
Like your desk? What?
This is Sergeant Leroy's picture of his area of origin. Oops.
Got a couple grunts in there.
Yeah, we are. Oh, should be coming.
I think the judge has to push some buttons, maybe.
There we go. What did Mr. Leroy's area of origin look like when he was there? You see this? Right here, that's the first floor fireplace that we've been talking about. Here is a chimney chase that we were talking about. We'll talk about more about that. But here is the 2 feet of debris in this 20 by 20 living room that extend from the fireplace all the way to the bay windows. And what was his testimony under oath to you? Greg Stormzan and I cleared the entire living room and deposited it outside. And he said my pile was 4 feet by 8 feet by 7 feet high, as tall as Shaq. When you do the math, that's nowhere near an 20 by 20 by 2 cubic feet. That's about 28% of it. I had a calculator. And what did it look like when the next person came? The next person who came was Mr. McHugh. You remember that? And he took a picture of the back. He was there on the 10th. 2 days after Sergeant Leroy, on the 10th, he testified, I think it was yesterday, maybe the day before, and all he saw was this. And then Mr. Shinsky came, and Mr. Shinsky came a couple days later on the 11th, and his picture was better. But I ask you, where is this 4 foot by 8 foot by 7 foot high pile that Mr. Leroy said he excavated?
I see 3 piles.
Somebody steal it? He actually almost said, I don't know. Maybe. Here's the thing. You remember Mr. Shinsky? He said, I had to come back on the 15th with an excavator because it was too dangerous. So if it's too dangerous for a veteran like Mr. Shinsky, who, by the way, trained Mr. Leroy, then you know Mr. Leroy wasn't doing any excavation of the whole living room floor, and there was no clear 20 foot by 20 foot area. Shinsky's picture, after they came back with an excavator, you remember, here's the fireplace area, and there's the living room, goes out to what would have been the bay windows. look at all that rubble, look at all that debris. I could basically, and by the way, Mr. Shinsky testified that he did the excavation. How do I know what he exactly said? Because I have his transcript, and we have his words. And his words were, in reference to the structural damage, you would then have to contract with someone else to come out and do the excavation of the house. Correct? No, I conducted that. You did the excavation yourself? Yes. Physically, hand by hand? Physically, hand by hand. And hired an excavator so we could remove the areas of the house that were hanging over the burned out section of the rear of the home so that it was safe to get in and actually do that.
The walls were pushed
in. And then
in.
he continued, how many days did it take you to perform the excavation of the property? He said, I believe I was there for 2 days. You remember when Mr. Leroy first told you that he looked for his pictures of the excavation and he couldn't find them. And then this half-truth, sometimes you just got to keep asking questions. And then you get to the truth. And then he says, I didn't take any, and I didn't make any reports. His testimony is directly contrasted by Mr. Shinsky's. And what was his excuse? It was a long day. I was tired, and I forgot. You remember I asked him, would you take that answer from some of your training? What was his answer? Yes. Well, it depends on the fire. This is a death case. It doesn't get more serious. Like Mr. Stormzan said, you have to bring your A game. Leroy, I can say it in lawyer terms, his story was demonstrably false. But if we want to just be real, he lied to you. And if he lied to you, you can't trust his opinions. Because if you can't trust the messenger, you can't trust the message. So when you go back and you analyze Mr. Leroy's work in this case, think about that. He lied about the very thing he needed to do, step one, collecting the data, so he could get to the conclusions, so he could develop the hypotheses, so he could try to figure out what went wrong and caused this fire. And you know what he said about that? He said, I didn't take any evidence because it had no evidentiary value. You see, there's that half-truth again that Ms. Zuderman has been talking about. You're right, you didn't take any evidence because you didn't look to find any evidence. When you analyze what he's doing, look at it in terms of his credibility and the high burden of proof. If you have any reasonable doubt about any of his opinions, especially when he lied to you, that's all you need. And when you have one reasonable doubt, ladies and gentlemen, about any issue, your job is done. Your job is done once you find one reasonable doubt. There's only two questions, really. You're going to hear, and I'll tell you about the verdict form and first-degree felony murder, first-degree murder, second-degree murder. It's all about, did she set a fire, and was it intentional? That's it. And you remember, well, we'll talk about it in a little bit, but as I said, one of the jurors was we were talking about half-truths. When my kids, I think they're lying to me, I just keep pressing, and then I get the answer. We kept pressing, Leroy, and then we got the answer. So I want to look at these experts in this case, because this is very important. I brought to you Bob Trenkle. Bob Trenkle is almost a 60-year veteran. Got born and raised in Detroit, cut his teeth in Detroit, literally the murder arson capital of the world back then. He has trained people, taught people, tested, been on committees, and what did he tell you? He spent 2,000 hours in this case, 2,000, over about 10 years. And when I asked him, how much you charge? Like $250 an hour? And then Mr. Blair came up, he couldn't wait to do the math. And they said, I'm not charging anything in this case. I think there was a question. If you're not charging anything, this is America after all. You must have a personal relationship with family, with Linda Stermer. There is no relationship. He spent 2,000 hours in this case. He knows every piece of the evidence. He knows everything that Leroy did and Shinsky did. Leroy spent less than 6 hours on the scene and developed his report. You know, he spent more time testifying, defending his opinions than he spent on the scene getting his opinions. And when you think about this, these are real questions that need to be asked when you go back to the jury, these kind of devil's advocate, cynical questions. Mr. Shinsky is a veteran, way more experienced than Mr. Leroy, taught Mr. Leroy. Mr. Shinsky was actually at the house, as you saw, same time Leroy was, same week, did the excavation, did an investigation. Why didn't they hire him? Why didn't they hire Mr. Shinsky to come in and tell us how good Leroy's opinion was and his methods? Maybe because Shinsky said, I did the excavation, and he would have known that Leroy lied. And the other thing is, Mr. Shinsky was asked to read this interview. Remember, read nothing but a transcript, bored the heck out of all of us. He's a fire origin and cause guy. He determined the origin and cause. Why didn't they hire him and ask him his opinions? Maybe because he disagreed with Mr. Leroy. And if you think there's any chance that's supported by reason and common sense that Shinsky disagreed with Leroy, that's an intentional fire, and maybe he determined based on all the damage that you can't just get every scene. It's undetermined, like Mr. Trenkle. That's why they didn't retain him. That's why they didn't hire the second most experienced guy who you saw in this case. And you know what? Greg Stormzan was with him. You remember he was his partner on that excavation. Stormzan said, well, you got to document so people can understand what you did. And it'd be the guy who was supposed to, I was just assisting because it's not my jurisdiction. He's the one who's supposed to take photographs. He's the one who's supposed to report. He didn't. You can't just omit this stuff. And when you think about this poor excuse of I was tired and I forgot, did you forget to write a report? Would you forget you were tired when you were writing a report and left out the excavation? Or maybe you didn't do it. Maybe you didn't do what you said you did under oath to us. If there's any reasonable doubt about Leroy's methods, how he failed the scientific method, anything that's supported by reason and common sense, no matter how small, that's reasonable doubt. And when you get one reasonable doubt, you're done. Not guilty. By the way, Mr. Leroy really kind of has an inherent conflict of interest when you think about it.
Inherent? Is that a new word?
He's up here defending his own work.
Should be inherent.
And nobody's defending him. Like I said, he spent more time in the last 18 years defending what he didn't do than he spent getting the evidence. Follow the science, ladies and gentlemen. When you look at what was done here by Leroy, follow the science, what he collected, what he analyzed in 2007, and not what they're trying to suggest, well, so-and-so backs you up on this in 2024. That's not when he did the investigation and the lack of excavation. 2007 is when you hold him to the evidence that he collected and his analysis. Follow the science, follow the objective evidence. We brought you objective evidence. And by the way, defendant has no burden of proof. We don't have to show you anything. We didn't even have to call a witness, but we did. Called Mr. Trenkle. We called Dr. Z, who said this is a 5-mile-an-hour impact. We'll talk about that as it gets to whether Linda Stermer intended to do anything. But let's talk about the reasonable doubt in this case. Starting with, as I said, Mr. Leroy's conclusions And so because I didn't want to write it on the board, because my handwriting kind of sucks. Here, Leroy's opinion. Opinions are not reliable. Garbage in
Use a yellow
equals
pad.
garbage out. And there was a whole lot of garbage in what he didn't do. You can't trust his opinions because you can't trust his methods because he didn't do it. He didn't comply with 921. He didn't comply with the scientific method. Did Leroy rule out an alternate area of origin? You remember Mr. Leroy agreed with me. His living room here is about the size of this courtroom all the way to the bench. Sometimes, as you saw NFPA 921, it says sometimes the damage is just too much and the area is too big and you can't make conclusions. You heard Mr. Trinkle. Ideally, you're trying to get to a point of origin. It was the back of the toaster. It was the electrical outlet. The bigger you get, the worse your reliability of your opinions are going to be because they're just too much. And by the way, when you look at this and you're considering reasonable doubt, think about this. I stood here. Could the fire started here? Don't know. Could the fire started there? Don't know. Could the fire started there? Don't know. He can't tell you the where. If he can't tell you the where, you can forget about it. Because remember what NFPA 921 says? If you're not in the right area of origin, you can't find the cause. Because the cause is going to be in the area of origin. But if you don't look, and if you don't excavate, you will never find it. So then we talked about alternate areas of origin. Remember that chimney chase? And Mr. Trinkle said, the chimney chase, you heard from Cassandra Grigg, one of the witnesses yesterday. She talked about, first of all, how everybody talked about this house was unfinished. The whole living room is OSB pressboard, subfloor with a couple throw rugs. And the chimney, the surrounding area, was pressboard. You didn't hear them bring anybody to say it wasn't. They could have asked the two boys. They had them up there today. What about the chimney? They didn't ask that question. There's a reason they didn't ask that question. They didn't want to hear it out of their own witness's mouth. Could the chimney chase reasonably be a possible area of origin? Well, Mr. Trinkle told you it's consistent with the witness reports of a fire from the back rear of the place, flames shooting out of the roof, chimney chase. That chimney chase is 2+ stories high, and if you have a problem in the chimney from the flue, which you saw the rubble he didn't even analyze, then you can have rubble pouring down, and by the laws of physics, things don't drop straight down. They go in arcs. They go out and down, in an arc. And when you have a wall collapsing, that would be consistent with getting Todd in the living room. That would be consistent with his burns on his hands. And that would be consistent with a pretty sudden fire and him screaming. So we don't have to prove that it's the chimney chase. We're not here to prove that the chimney chase is where the fire started. He can't rule out the chimney chase could logically possibly be the area of origin because he didn't do the work. And if you can't rule it out, that's reasonable doubt. So let's look at the next one. Gasoline was on sweatpants, not related to the fire. Can he rule out that maybe the gasoline he found on the sweatpants had nothing to do with this fire? Well, you remember his testimony? At least he was candid with me, because I had his old testimony from 4 years ago. He has no opinion on whether the gas on the sweatpants had anything to do with this fire. He said, I don't know how it got there. I don't know where Todd was when it got there. I don't know when it got there. I don't know when the last time the pants were washed. I don't know any of it. So finally he was candid enough, because I had him trapped, to say, I don't know. I have no opinion. Well, that's the whole linchpin of his whole gasoline in the house. because he admitted there's no gasoline in the living room. None was found. None. If he can't rule out that the gasoline has nothing to do with this fire, then you have to return a not guilty verdict, because that is reasonable doubt. That's the whole basis of his opinion. I'm sure you folks have notes on that. Now, this is important. The other thing that can cause reasonable doubt is, do you remember when I was asking him about his opinion, he relied on Linda Stermer and her testimony about being in the laundry room and running upstairs when Todd screamed. He was upstairs, she's downstairs. You remember, you heard a lot of talk today about all the inconsistent stories. What you've heard from every single witness who talked to Linda Stermer is that she was downstairs and Todd was upstairs when she heard this horrible scream and he was on fire. And she ran upstairs, and then her world turned upside down. So,
she had to run over her husband. Oh, here we go. Gonna go all the way back to who smelled gas. That's how we started this. Oh, finally.
Todd.
Squeak, 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 squeak.
Was upstairs. Linda.
Can you label it so I can tell?
Forgive me, that's how my mom used to draw her when I was a kid. Was downstairs. She was downstairs and had to run upstairs.
Can we zoom in on that?
Even Sergeant Leroy agrees with the obvious. You can't be two places at the same time. That means when he caught on fire, she wasn't there. She wasn't with him. And the interesting thing is, oh, wait. Interesting thing is,
fire doesn't work.
When Mr. Blair apparently realized this is checkmate on reasonable doubt and where the fire started and the cause of the fire, he started asking, well, isn't it possible that maybe she could have poured gasoline on him and ran down the stairs and there was all these fumes and she didn't get any gas? She didn't get any gas on her after doing that? Testing to 0.0005, not a drop, not a speck on that high-tech machine.
Or she changed.
No, there's no such thing as possibility. You heard every legitimate expert say, we don't guess. Because guesswork masquerading as expert opinion testimony is junk science, and it's frankly unethical. We don't do that. So this idea of they'd like to show possibilities, you don't deal in possibilities. You are the judges of the evidence. But the evidence from their expert, I'm not an expert at fire science. You're not presumably an expert at fire science. You have to rely on the evidence that you heard from the witness chair. And the evidence from Leroy and Mr. Trankel was she was downstairs, he was upstairs. She wasn't with him. If there's any reasonable doubt that she had nothing to do with the fire, not guilty is your job. What's another reasonable doubt?
Tried to scribble orange fire, but his marker doesn't show up on his yellow legal pad.
No evidence of an ignition source. Let's talk about that for a little bit. Because you don't collect any evidence, he couldn't find any evidence of an ignition source. You remember we talked about NFPA 921 and the causal factors. Causal factors, if you'll recall, you look at your notes, are you have to have an ignition source and you have to have a first fuel. Ignition source, what's the thing that made something catch fire? If you're at first fuel, what's the first thing that caught fire? And most importantly, how did 1 and 2 come together? He didn't have any evidence of an ignition source, so he supplied one and said it's an open flame. Could be from the fireplace, could be from candles, don't know. Well, he didn't rule those out either. And then he said gasoline, but see, this is circular, because he said gasoline on the sweatpants, which he's admitted he didn't know how long it had been there, means there's gasoline in the house. That's completely illogical. He didn't have a first fuel. And he certainly couldn't put 1 and 2 together to tell anybody what caused the fire. How did the first fuel, even if it was open flame, 2, gasoline, how did it come together? What's the first thing that happened? Doesn't know. What's the second thing? Because you have to, as an expert, you have to do this. You have to say, this is the first thing that caught fire, and based on our training and experience, we know the fire propagated this way. This caught fire, then they caught that fire, and they caught that fire, and caught that fire. You tell how the fire started and how the fire progressed. He couldn't do that because he didn't do step 1 of the scientific method. He didn't collect the data. Garbage in equals garbage out. And when there's garbage for the out because of garbage from the in, that's reasonable doubt. Doubt calls into question the confidence in his opinion based on reason and common sense. Reason and common sense tells us you can't be where the fire started if you're downstairs. He couldn't give us the how. Frankly, he couldn't even give us the where because he doesn't know within this huge area of origin where the fire started. Number 9. Since he couldn't tell us the cause, he certainly can't tell us the classification. Accidental fires, natural fires, lightning strikes, undetermined, and incendiary. Incendiary is the only classification that supports a crime. And if you don't have a cause, you can't have a classification. If you don't have a cause, the only intellectually honest thing you can do with integrity and honesty is say, it's undetermined. And there's no shame in that. Because sometimes fires are just too total. The damage is just too much. Did he rule out an electrical or mechanical cause of the fire? Well, he's admitted he's not an electrical expert, and he's admitted under oath that he didn't collect anything. So how could he rule something out that he didn't collect? And what does he do? He explains that, well, electrical fires in walls, they start small and slow, and so this is why this whole able-bodied thing comes into play, and an able-bodied person, if it was electrical, could figure that out and escape. Electrical fires in walls can explode all the time. Happens all the time. Did he exclude and rule out a mechanical cause? The flue. You saw all that damage to all the flue pipes. That's why we bring in people and they look at it and they try to see what could have been a failure of the flue, and that's how things started in a chimney chase. He's not an expert, he said that. He didn't collect the data. You saw how Shinsky laid out the stuff like you're supposed to do. What did Leroy do when he was tired and it was a long day? He threw the stuff in a pile in the back of the house. And forget about 123. Nope, 30. We'll get it. You remember Shinsky's photo. He just piled it. There's no analysis, there's no thorough investigation, there's no thorough, rigorous testing, which is what NFPA and a scientific method say you have to do. He just threw it out so he could go home because he was tired. And remember I asked, why didn't you just come back the next day? He didn't have an answer for that. Wouldn't you have told your young associate? Nothing wrong with going back. Why didn't you go back? And why didn't you write a report? And why didn't you do what you were required to do in this death case? Then he didn't rule out contamination of the sweatpants. Remember, he found 3 hours later Todd Stermer, and he smelled gasoline. We'll talk about that in just a second. He smelled fuel. I shouldn't say gasoline because he said, at least he was honest. Fuel is fuel when you're smelling it. I don't have a super nose. So he smelled fuel, and that's why he took the sweatpants. But remember, he's there 3 hours later, and this is the final point of rest for Todd Stermer after he's been taken in this boat to here. So if you find in here, you have to analyze, could there have been a transfer to the boat, or you remember, Matheny
spent all
put
week
clothes
working
on
these
him, a bunch of
pictures.
clothes, and they found that here, right? Could there have been a contamination from there? It's not whether there was, it's whether he can rule out the logical possibility that there was. And how do you do that? You use the scientific method like all scientists do, like all professionals do, and you collect data, starting with the boat, working backwards. I asked him, did you use a rag, anything? No. Did you talk to anybody? No. Talk to the family? No. That's all data. No. I don't even think he knew there was a boat involved. So he couldn't collect the data, so he couldn't do the rest of the steps, so he couldn't comply with the scientific method, which means that his methodology is garbage, so any opinion that says that didn't matter, that's garbage too. If he didn't rule it out, that's reasonable doubt. These are 11 different things that I've come to. When you go back, you were taking a lot of notes, you might find more. When you think about all the evidence, you might think, let's look at that. Did he consider that? Maybe that's reasonable doubt. You might find more than I did. But you don't take possibilities. Pros don't take possibilities. So when Ms. Zuderveen, like Mr. Blair, says, was it possible that this happened? That's not evidence. That's speculation. That's guesswork. Experts don't do that, and you can't accept that as valid evidence. Not only was there Mr. Leroy's shortcomings, but you remember a lot of the police witnesses who testified. Oh, let me segue here. Let me just back up just a little bit. Do you remember all of a sudden, remember this fire chief who had been retired for a lot of years, and he comes in, he said, I've done hundreds of fires. And all of a sudden he remembers,
I think you meant fire investigations.
I smelled fuel too when I was there. He didn't write any report 18 years ago. He's never said that ever in any document. But he admitted, I met with the prosecutor, and we talked about what my testimony was going to be. So it's kind of weird that all of a sudden people 18 years later are saying things that they never said and never wrote. So when you consider credibility and the credibility of the witnesses as you're analyzing whether there's reasonable doubt, think about that. Every law enforcement person who came in and said that they smelled fuel at the scene on Todd Stermer never said it before and met with the prosecutor to prepare.
He's insinuating the prosecutor told him to say that. That's more of a logical jump than anything the prosecution
One more
is asking
thing
the jury
I
to
did
do.
forget. there was talk about the construction of the house. And this is real important because as you're analyzing, how could the fire have started? Could it have been an accident? Remember Brad Stermer, the older brother? He said, I was in college, and remember we had that yellow house that was my dad's, and Todd was the main guy working on it, and he said, I'm a handyman, and I'm good at it too, but we didn't have any money. I think the phrase was, we were scraping nickels together to get it fixed. And he admitted, we didn't use the best equipment, the best components as we were doing the house. And 5 months after they finished, with Todd at the helm, being unlicensed, that place burned. And he said that was an accidental fire. Well, that can happen when you don't have licensed contractors, and good as you may be as an amateur, you're not a licensed electrician, you're not a licensed mechanical person, HVAC, nothing. That can happen, and you can't rule out that that happened in this case, and we know why. Because it took, what, 6 years for this house to be built? You're scraping nickels if it takes 6 years to build a house. You're doing what you can when you can afford it. You heard, and maybe it's because of the horses, but you heard they were having money troubles. That's why they didn't build it. That's why they were scraping nickels. And he was at the helm. And you heard, not only did you hear from all the people who have been in the house about all the exposed wood, which is why it would have gone up so fast, because it was a tinderbox. Then you heard the last witness we had, Rich McGrew, who said if you don't get a final electrical and a final mechanical, and we don't certify it as good for final occupancy, it is a unsafe house. Why unsafe? Because you can have fires. So you're not here to supply evidence, you're here to address the evidence that was given to you. And in that sense, you can't rule out that because of poor construction, this could have been an accidental fire. And the fact is, because it's a tinderbox, that also explains the speed of the fire. But at least Leroy was candid enough when I questioned him and caught him in some demonstrable untruths that he said, yeah, I didn't know how the house was built. I didn't know that it had OSB flooring. I didn't know that there was no final certificate. I didn't know that it didn't have final inspections. That's all data that you can collect that's available. You know who collected it? Len McHugh, the property adjuster, who, by the way, Linda Stermer asked him, why are you here? Because we don't have insurance. We'll get to that in a second. But he's the one who collected the available data, he said, from the building department, which is what Leroy could have done, but chose not to. Garbage in equals garbage out, makes it unreliable, it can't be trusted, and if it can't be trusted, that's reasonable doubt. Now, let's talk about the police work in this case. In this rush to judgment, where they first, I will say, they got misled by Leroy, who called it an incendiary fire. So in their terms, in police terms, that's an arson. And we have a guy who's dead and we have blood on the bumper. Now their rush to judgment resulted in all kinds of sloppy work. First of all, this missing video that we're talking about, which would have helped anybody, including a defendant who's under arrest, determine how the fires was spreading, that's gone. You heard Cynthia DeLoach, the gas station attendant. I asked Maciaski, you got the cash register tape and the video from the place in February of 2007, a few weeks after. It's stuck in your drawer for 2.5 years. And is that proper protocol for property preservation? I'm not sure what the protocol was back then. You're a veteran cop. Your command staff. You don't know this? Or is this just another half-truth? Mislabeled evidence. Remember that coat that was in the silver can that turned out to be Mike Matheny's coat, that red checkered one? That was labeled Todd Stermer, which helped Leroy determined, well, everything that's tested positive for gasoline is Todd Stermer's. Therefore, couldn't be any contamination. He didn't realize until later, oh, that's Matheny's coat. And he didn't rule out the contamination from Matheny's coat or the boat. If he didn't rule that out, that's reasonable doubt. Witnesses weren't interviewed for 2.5 years? Cynthia DeLoach didn't get interviewed until 2.5 years later, June of 2009. And remember the testimony from her? I knew Deputy so-and-so, and he'd come in all the time. Have you talked to the folks? Have you talked to my bosses, whoever's running the investigation? No, nobody's come to talk to me. Remember Maciaski, who said, I got too busy and I forgot. Everybody seems to forget here. He got too busy. He didn't go see her for 2.5 years. When you look at it with a bit of a jaundiced eye, this other detective, if he's going to Cynthia DeLoach, what'd she say, every month, every 2 months or so, have you talked to us? Have you talked to our guy? Have you talked to our guy? You think he's not going back to the department? Why don't you talk to this woman? She's got evidence. He didn't do it. And by that time, she forgets, because you heard her testify. I don't know if Linda Stermer was pouring gas. I didn't know, she said, I think she was, but I didn't see a container. Now, think about this, because I want to talk about this red gas can that was found in the front yard. And they're trying to relate it, one to the fire and all the way back to Cynthia DeLoach. This gas can that was found by Leroy.
1 gallon, $11 gas purchase. That means
you can see
gas had to go somewhere
has
else.
A broken spout. He didn't know how long it had been there. This gas can that tried to relate to and make this big conspiracy by Linda Stermer, she went and bought gas in the morning and she put gas in the truck. Linda Stermer is all about 5'6". Chevy Blazer, remember the talk was the hatchback. 5'6" woman doing this into a gas can, and you didn't spill a drop of gas. You didn't spill any gas. You didn't get it on your clothes. You didn't get it on your hand. How do you pump $11 of gas, roughly 4.5 gallons, into a 1 gallon tank? You don't, because there was never any gas being pumped into a gas tank. And how do we know that? Because Trevor was honest enough when he testified to say, remember when we went to the mall in the Blazer? I didn't smell any foul smell. You know what gas smells like, right, Trevor? Yeah, I know what it smells like. You didn't smell anything, did you? No. Anybody, including me, when it's time to use a snowblower and I got to go to the gas station with my gas can, I put it in the truck of the SUV, it smells. And I may not spill a drop. But anybody who spilled gas on clothes or their hands, it reeks for a while. So when you think about credibility and what is trying to be portrayed as this grand scheme, reasonable doubt. Was this even connected? No. The most telling evidence is their expert, Leroy, said, I have no idea. It has anything to do with it. So what you're being told by the prosecutor is some theory based on no evidence, trying to connect dots. But it's a bridge too far, a road too long. You can't connect dots because all you're doing is guessing. And you as a jury have to evaluate the evidence, not the talk of me, not the talk of Ms. Zuderveen. Judge will tell you that. What we say is not evidence. What they said was evidence. Leroy said, no idea. No idea. Now, we have all kinds of reasonable doubt, at least 11 things, just in terms of how the fire started or where the fire started. But now I want to talk about the second part of it, intent. Did Linda Stermer intend to set a fire? Let's look at the objective evidence. Then we're going to talk about all these 5 ways that Ms. Zuderveen said Linda Stermer tried to kill her husband that day. 5 different ways, and we'll analyze that against the objective evidence we have. First, the thought and the theory by the prosecutor is Ms. Stermer struck Todd in the van, therefore she intended to kill him. Well, let's look at that through reason and common sense. And if you lack confidence by using your reason and common sense, that's reasonable doubt. You heard the 911 tape. That, as you know, was Connie Calhoun, and you saw her stress level, the chaos she was going through. She wasn't in a fire. Her spouse wasn't on fire. Her house wasn't on fire. And you saw how she was.
Her spouse also wasn't trained to tell people what happened.
And by the way, every person who testified here from law enforcement or people like Connie Calhoun and Mike Matheny and Dr. Masali all testified she was hysterical. She was beside herself. Now,
screaming was Linda.
She would have to be the greatest actress in the history of Hollywood. Meryl Streep would have nothing on her. And by the way, remember the theory that Ms. Zudovine just told you?
White drag.
She was driving down the driveway. She was escaping. Let's look at that. Through reason and common sense, and see if we doubt that statement. Who is a mastermind who supposedly got gas in the morning in a gas can to torch a place, scooted the kids out, and then is escaping, as she said, and escaping with no shoes, and escaping with no coat in January, and is escaping with no cell phones in January,
But with her purse.
and is beside herself, hysterical. All it takes is a little bit of doubt based on reason and common sense. And anybody who heard that 911 call cannot come to any conclusion other than she was shocked by the fire and she was in a state of panic. And you heard Bob Trenkle. Firefighters, police officers, military folks, they train so they can have muscle memory when the stuff hits the fan. She's a middle-aged woman who never engaged in any of that. And she acted like it, like she lost her mind, because it's fight or flight. And she ran, but she wasn't escaping. She was trying to get help. And it is pretty darn cynical to listen to that 911 call and to say she was trying to escape this mastermind was. Now, there were talk about valuables in the house. One of the things you look at, as any cynical person like Willison would be, is if you're going to torch your house, I want to make sure my pictures of my kids and all my valuable stuff and all my guns and everything else are out of there. Then I'll torch the house. Remember, Trevor's baseball cards that were so valuable to him were found in the basement in the rubble. And you heard from Tina, Benny, and she said, my husband and I, we had this handmade little sifter, and we found a wedding ring, Linda's mom's wedding ring, valuables that were in the rubble, by using equipment that Scott Leroy should have been using, that he has, that they use. So this idea of you hide valuables, reason and common sense. And reason and common sense tells you if you have a financial motive, you kind of know you had insurance. Len McHugh said, she asked me, why are you here? We don't have insurance. Our insurance lapsed. This is the financial motive? This is a get-rich-quick scheme by this mastermind? There's no intent. There's reasonable doubt as to every bit of intent here. Oh, then let's talk about these 5 ways, the 5 best ways to kill your husband in the same day.
Sounds like an Amazon bestseller.
First, she tried to drug him, then set a fire. Where'd that come from? Kate Fox with a coffee cup, remember? But Kate Fox told us, Linda Stermer said, I put the coffee cup and I didn't drug him because he was already on tranquilizers. Let's look at the objective evidence about that. Dr. Markey told us in no uncertain terms that there are no drugs in the system. And when we talk about who's being square with you and we want to have credibility, Dr. Markey said the remnants, the metabolites of hydrocodone were in the urine. That's not active. There was nothing but caffeine in the bloodstream, the active ingredients. And the metabolites that are in the urine, which last longer, were explained by the medical records that we just admitted today from the family physician who prescribed Entex HC, a narcotic for the ear infection that has hydrocodone. Dr. Markey admitted hydrocodone is consistent with taking this cold medicine that the doctor prescribed. So when we're talking about what the evidence represents, like I said, thank God what we say is not evidence. You can rely on your notes and you can rely on the transcripts. Well, you can't rely on it, I can. And also, Ms. Stermer said that Dr. Markey had no opinion as to whether the skull injuries, the lacerations on the head, were related to the van versus something else, which you're suggesting is a frying pan. Dr. Markey said on page 18 in his testimony, those injuries that you saw to Mr. Stermer are consistent with having been run over and striking various undercarriage components, isn't it? Well, the injuries themselves, as I stated before, very well it could be to being struck and overrun and striking things on the undercarriage of the motor vehicle. That's his actual words, not what you heard he said. And you can look at your notes, because these are the actual words under oath. And it's consistent with Dr. Zacheski, I just call him Dr. Z, who is a renowned biomechanics injury mechanism expert with decades of experience working with brain injuries, who told you all of the lacerations and these skull fractures. It sounds bad, a skull fracture. A depressed skull fracture has been explained as you take your finger through some icing on a cake. It doesn't even hit the bottom of the bone. There's no linear skull fracture. There was no brain injury, as Ms. Zuderveen tried to suggest, Markey said. That's not on the autopsy. These are AIS-2 injuries, Dr. Z said. Moderate injuries. Not related, there's no evidence that it was related to a frying pan. So that's the first one, drugs set them on fire. Number two, crack them with a frying pan, then set them on fire. Except that came from Dardita Gordon, who admitted to so much mental illness and on so many medications normally that she would have been, except she was in jail when she gave that statement. And she said, they don't give me my meds in jail, and I have memory problems. And guess what? She admitted that it was Detective Macioski who suggested, could it have been a frying pan? It was a jailhouse snitch. Yeah, I guess it could have. You look at all of this with a cynical eye, and when you're evaluating the witness's credibility, that's unreliable. That's not consistent with the physical evidence. We don't have to prove anything to you, but we bring you objective evidence, follow the science, follow the objective evidence, and you can't come to any other result other than there's reasonable doubt. And by the way, what devious mastermind who's going to torch the place and kill her husband spends the afternoon packing up Christmas decorations? What, an hour before I'm going to torch my place and kill my husband? None of this makes sense. Starting with all these witnesses who prepped with the prosecutor and all of a sudden change their testimony or hear new testimony. So frying pan is number two. Setting the fire by itself, well, we already talked about that. That's clearly reasonable doubt as to where the fire started, no doubt as to Linda Stermer didn't have anything to do with it, and you didn't hear a single word from Mr. Leroy or the prosecutor that gas on the sweatpants had anything to do with Linda Stermer. Because if they had that opinion, it would have been front and center. It would have been blown up on a wall 10 feet high. No opinion, your notes, you can pull them all. Nobody will find a note that says that. The gas on his pants, which he claims is the whole key to the case, that it had anything to do with Linda Stermer. 4, run them over after you set the fire. Well, you heard testimony from Dr. Z that it's a 5-mile-an-hour impact. And those injuries, you didn't see anything where he was run over by a 4,500-pound vehicle, no broken legs, no broken bones, rib fractures consistent with CPR, no brain injury, no skull injury, no nothing other than icing on the cake and some lacerations consistent with being run over at a low speed, as Dr. Z said, with a high load. High load is just, it's 4,500-pound van. And Dr. Z's testimony is undisputed. Because don't you think, with the resources that the government has, if they could find anybody, and I mean anybody, to counter Dr. Z or counter Dr. Markey, that they would have? But this is the same group that's letting Leroy defend himself. They won't even hire Shinsky, because Shinsky's not going to go their way. And finally, the fifth way she tried to kill him that day was to suffocate him. So here she is in this panic state of chaos, fight and flight, and out of her mind, and she's yelling, Todd, Todd, stay with me. And what did they say? We think she was laying on top of him. She wasn't laying on top of him. She was trying to hold her husband and keep him alive. And if there's any little doubt that you have that's supported by reason and common sense, that doesn't require you to abandon reason, then that's reasonable doubt. And if there's reasonable doubt, you have to vote not guilty. There's no intent here. Clearly a reasonable doubt as to the intent and lack thereof. I'm going to talk a little bit about the inconsistencies, and of course, there were a lot. But you know what they were? They were details after she got to the top of the stairs, when her world blew up. While she was downstairs and calm, everything's consistent. I'm in the laundry room, and Todd is upstairs, and that was relied upon by Leroy in terms of finding the area of origin. It corroborated his physical findings. His physical findings corroborated her testimony. Nothing about these witnesses that they're bringing you is being corroborated. We talked about how Mr. Trinkle said how people train so they hope they can combat panic when the adrenaline is high in a stressful situation. And when you're in the jury room, I want you to think of this. A lot of people Monday morning quarterback and go, I wouldn't have done that. I would have jumped on my husband. I would have saved him. While you're having a cup of coffee in the jury room, or you're watching TV in 2020, I would have done this, I would have done that. You don't know what you would have done. What you would have done and what you could do in the situation are two vastly different things. So when you're thinking about what she was going through, you have to put it through the lens of this high burden, this presumption of innocence, and that none of us know, unless you've been in a fire and running out in your underwear, what people go through.
If you haven't run out in your underwear, you would not understand.
I'll talk a little bit about their witnesses. Not much, frankly. Certainly not going to go through every witness of theirs. Let's talk about it. We talked about Dardita Gordon. Let's talk about Kathy Ilge, who's the one who said that she talked to me about the coffee cup and the drugs, and that she found jewelry in the van, Linda Stermer's van that she drove, remember, within a week or two of the fire. And in the center console was jewelry, which to a cynic would mean you're kind of squirreling away stuff, the valuables, because you don't want them to burn up in the fire. Well, look at the objective evidence in this case. First of all, you remember Kathy said, within 2 weeks of this, I'm in the van. And in the center console is the jewelry. Do you remember the van was confiscated by search warrant that night and examined the next day? The picture of the center of the console of the van, as Macioski showed, taken on the 8th the next day, there's no jewelry. And Macioski, who's supposed to put a detailed report together anytime you do a search warrant, it's the property you take and confiscate and take into evidence. never mentioned jewelry because it didn't exist. And here's the kicker. This is a murder investigation. What police department in a murder investigation involving a bloody van is giving the key evidence back to the family in a week? Think about that. When you're back in the jury room and you're thinking about the credibility of these witnesses, no police department. This is a murder investigation, and that is a critical piece of evidence. You don't give it back to the family. Oh, the other funny thing, among many, is that she said, let's strike that. I'm going to go to Kate Fox. But Kathy Ilg can't be believed. Her testimony is unreliable. And for them to put somebody who would talk that crazy and that to give testimony that is so demonstrably false by the evidence, you have to wonder as you start to think about these weird things, why are they putting up these witnesses to talk about things that would be impossible, that are demonstrated to be impossible? Maybe because they can't talk about the fire. Maybe they want you to dislike her so much you ignore that there's no evidence of a fire being caused intentionally. And nobody can prove it, so we want you to dislike her. We don't want you to think highly of her. She had an affair. She said this, she said that. She treated Todd badly. Because we don't want, in 90 minutes, they talked 5 minutes about the fire. Why we're here. And in the 5 minutes, you heard one sentence. Leroy said, it's consistent with an intentional fire. She didn't tell you about the evidence that supported that. She didn't tell you that we don't know how the fire started. We want to give you the why. We want to give you the motive. But we don't want to tell you how, because we can't. Let's talk about Kate Fox. Kate Fox came in here dressed really nice and talked about a coffee cup and the drugs. Remember, we talked about Dr. Markey, how he blew that apart. But the other thing that struck me is you were supposedly best friends with Linda Stermer, but because her sons lost a father and she had to take care of them and she had to switch a shift, you felt like she betrayed you? And so maybe you have an axe to grind. And when you look at her credibility, let's measure this against the credible evidence and the objective evidence. Linda Stermer, while she was carrying on this affair, told me to close up her post office box because her husband was going to find out. The federal government allows a stranger to come in and close somebody else's post office box? Really? They want you to believe that? This is who they're putting up.
They give
as
my
a
mail to
credible
other
witness
people.
to talk about she confessed, she did this. The objective evidence. When you're evaluating credibility, look at what's out there that can't be true. And finally, Trevor Stermer, Trent Stermer, they came on. They both disliked the mom very much. They both only started calling her Linda instead of Mom after she got charged in 2009. And they were both living with Grandma Stermer before the trial and after the trial. Just take that in consideration. I tried to be as nice as I could, but I had to point out all the inconsistent statements under oath, and it probably bored you because every 30 seconds I was going, remember you're under oath, right? And you swore to tell the truth, and you did tell the truth. And eventually, after you ask so many questions, they go, yes, I was telling the truth when I said Mom was acting normal that day, which would be consistent with Mom's wrapping up the Christmas decorations and putting them away an hour or two before she's going to torch the place. You can't have it both ways. You can't have it both ways. You can't be this diabolical killer, master planner, so they can say that it's premeditation, and on the other side of the coin, you're saying she's going around wrapping up the Christmas decorations. And by the way, remember they said, not only was Mom acting normal, But if I'm going to torch the place, I'm not going to tell my sons, all right, see you when you get home. I'm going to say, don't come home for 5 hours. Or maybe you need to go to another friend's after you go to the mall. You don't say, just come home. I'll see you when you get home. That's not somebody who's premeditatingly going to murder her husband. And when you talk about, you're going to get a jury instruction about premeditation, it's going to be, there has to be some time connection involved with premeditation. Everybody has said a lot of things, maybe to their spouse, to their friends, or whatever, that they say in the heat of the moment, or tell their friends in the heat of the moment. But if this happened on January 7th, and she's telling Kate Fox this in the summertime before, that's not premeditation. That's not evidence of premeditation. There was no evidence of premeditation on January 7th. None. Talk about Chief Leach and all of a sudden his sudden memory. Oh, by the way, you do remember that Trevor and Trent also met with the prosecutor and all of a sudden remembered some things that they had never said before. Verge Franks, one of the police officers you saw first on the scene, smelled gas, but that's after Matheny's coat is on Todd Stermer. Didn't have a report, never said it before. I want to just kind of wrap it up this way.
Is wrapping up already? Why so soon? Please have coffee. Where's the coffee spill? Coffee spill, coffee spill.
In order for them to obtain a guilty verdict, they have to show that the actions of Linda Stermer caused the death of Todd Stermer. The actions can only be she set the house on fire because he died of burn injuries. I was thinking about showing you the video of the burn of the sweat. You've seen it. You know what happens to polyester pants. And the question was, well, if he was on fire, how did the pants not burn? Since they burn so easily. And you heard Mr. Krenkel, who cited NFPA 921, Chapter 24, that says we all know, well, we don't all know, but skin burns at about 110 degrees, 108 degrees. You get 108 degree temperature, your brain cells are burning and dying. Clothes, as it said in 921, ignition temperature, pretty much the lowest, is about 450 degrees. So that can explain the thermal burns, which he said, these were not contact burns. People who die in a fire when they've been immolated,
we've all seen
they look like a burnt hot dog. That wasn't this case. This was thermal heat burns, which explains why the pants weren't burned, which also explains that there was no gas on the pants in any amount that could be related to anything with this fire. Because I wear my sweats Friday, Saturday, Sunday, Monday, it doesn't matter. People do that. You can't tell how long the sweats had gas on them, the last time they were washed, where he was.
I wear clothes 4 days straight. Is that what he just said?
If he can't rule it out, it's reasonable doubt. And finally, I told you have rights. Linda Stermer has been fighting this since I've been with her for 6 years now. And Skip and our team. So now, excuse me, I'm going to turn her future to your hands. Follow the evidence, follow the scientific evidence, follow the objective evidence, and understand how high the burden is to achieve beyond reasonable doubt. Clear and convincing evidence, a firm and definite belief that any proposition is true, not good enough. If there is any doubt,
we're using all of them.
That's supported by reason and common sense, where you don't have to throw out reason, that's reasonable doubt. You deserve to be on a jury that holds the government to that burden that our founding fathers set forth. You deserve to be on a jury that holds the government to that high burden on every single fact that they need to show to prove those elements. They can't check a single box. Forget 3 boxes or whatever she was talking about. There's no evidence to suggest that this was an intentional fire. It was such a shoddy investigation by the fire sergeant, fire marshal, that there's nothing but reasonable doubt. People can't be 2 places at one time. And finally, they have to rule out reasonable doubt for every single element. You know why we're here, really? Is because Sergeant Leroy mailed it in. And 18 years ago, he destroyed Linda Stermer's life by mailing it in. So when you're deliberating and you have a conviction, and we said you took an oath to not mail it in. You took an oath, if you have a conviction, to stay as long as it takes and stand up and not be bullied by somebody who maybe wants to go home on Friday and doesn't want to come back because I missed 3 weeks of work already. There is too much at stake. A person's freedom is at stake. Don't mail it in. Todd Stermer mailed it in. Leroy mailed it in. And you know what? He not only did a disservice to Linda Stermer, but to Todd Stermer and to you. Return a verdict of not guilty on all counts. There's a verdict form that you're going to see. I didn't have a chance. We just got it this afternoon. We didn't have a chance to blow it up on a board. Possible verdicts. You may return only 1 verdict on each charge. Premeditated first-degree murder, not guilty. First box. 2, felony murder, the arson, not guilty. Everything depends on whether there was a fire that was set intentionally and was it set by Linda Stermer. There's no arson, there's no crime. If there's no crime, there's no premeditation. I'm going to put this in your hands to do your job and hold yourselves to your oath. Thank you. Not guilty.
Not guilty. Not guilty.
Thank you, Mr. Mueller.
Housekeeping time, Your Honor.
Break. Okay. I have a juror who needs a break. So we'll take a 10-minute break.
Thank you.
Okay. I have, we got a grunt there at the end. We did. We'll wait and see what happens here. How long was somebody timing him? How long was his closing? These were both long closings. The state's closing argument was 1 hour 48 minutes. How long was the defense? 1 hour 40 minutes. Oh, so it came in short. Thank you, Hipster, Katie Bug, 1 hour 40. Lindsay Bay, thanks for keeping the stopwatch on that. Did he flip me? No. I was more worried he was going to flip me off than flip my verdict. The emotional appeal at the end, it's interesting. I got a text from somebody, I don't know who it is yet, who said in Michigan, the amount you can collect for wrongful imprisonment is like $50,000 a year. So he may be working pro bono right now, but if there's an agreement, this is what the text said, if there's an agreement that he handles, oh, Jackie, thank you for that. If he handles the suit, the civil suit, suing the state for wrongful incarceration, that might be one where he would get paid on. That suggests an option. I'm not sure if that's the case. I'm not sure if that's the plan, if that's the next move. But he does wrongful convictions. Well, I watched so many times he talked about I cornered this guy and finally he admitted to me. It's like you bullied a witness into a just answer the question. Don't expand. Just say yes or no if I say this. And they're like, ugh. Every single time it was through clenched teeth. It's like you're forcing me to say something that requires an explanation. And then he wanted to base his whole argument based on their answer as if they were resoundingly saying, yes, that is nail on the head. That's exactly how it is. It didn't sell to me. It didn't sell. But I'm going to keep grunting until you come back not guilty. All I know is that as we look at juror questions towards the end of this trial, the further we go in the trial, the jury questions got more and more confrontational against the defense. They were taking a side against the defense. And it had basically the defense sort of backpedaling, the witnesses backpedaling who were testifying for the defense. I think the jury is leaning one direction already. It is 4:20 right now. I think here's what's going to happen. Here's my suggestion. Judge reads the jury instructions tonight, and then says we'll start deliberating tomorrow. That's number one. Option number two, judge reads the jury instructions tonight, says we'll just hang out here for as late as we need to, and we'll have once again a verdict during the podcast. But it depends. It all hinges on the fire investigator, for sure, 100%. But I think the defense's fire investigator, his weakest point was where he said the fire most likely, or can't be ruled out, that started in the chimney flue, or in the chimney race, or whatever it is. I forget what the term is. And that's the area where we have unburned 2x4s, which would have been exposed to that. I mean, it is. You've got the tube that all the smoke goes up, a gap, and then those boards. There's nothing between them, and they're unburned. He's like, oh no, because fire goes up. Fire goes up, but ashes fall down, and hot ashes fall down, and it would have burned to the bottom. It would have burned everything underneath. And that's where he lost me, where he was adamant that no, in this case, we can't look at the area that has the most destruction, the area where there's complete destruction, meaning the fire burned the wood there longest as the point of origin. We have to look instead to this area off to the side, which would make it a naturally caused fire, or not an intentionally caused fire, and that's it. So, chimney chase, that's what it was. Those unburned 2x4s weren't even charred. Yep, that's fine. The fire can be as hot as it does, just disintegrate everything else. It won't burn where it started. So that to me was enough for me to say I can't, as a juror, I can't take the defense's fire investigator and believe everything said. Now, I do believe that after listening to this fire investigator, that there was no liquid gas, like of any substantial quantity, on his pants, his underwear, or his socks. I cannot see that. And the demonstration the defense's fire investigator gave proved that to me, and I believe that. I believe it's right. I think the gas that was detected on him was caused by being in an area either with heavy fumes, say like gas was poured in the room or thrown on his shirt or something like that. And I'm thinking more and more that gas was thrown on his shirt and he ripped that off and made it out of the house. Yeah, we're just on a break for a little bit. We've just got a couple minutes break. Juror needed to run to the little juror's room. We've already asked what will the jury determine. We've got a vote. I think it came back about 84% said guilty. We've decided through poll how long the jury will deliberate, and most of you said what's for dinner, meaning it'll probably be late tonight. I think that's it. No more polls needed. Do you have a poll? We've done a poll. We can do one more because I guess even though the closings are not evidence, let's start another poll. Okay, now I'm going to word this differently. And if you've taken statistics classes, you'll know that this type of question generally elicits a more conservative response because I'm putting it on you personally. Hang on. And I'm also doing all or nothing because this is a case where either she intentionally started the fire or she didn't. The question is, how would you vote if you were a juror? Guilty or not guilty? Those are the two options I'm giving you. Yes, podcast tonight. We're on at 8 o'clock tonight. If we lean towards guilt, do you believe the theory that the fire took hold quicker than she thought and it messed up her escape plans? Kath, I would say that for anyone who's tried to light a fire with gasoline, they learn very quickly that fire takes hold much quicker than you expect. Gasoline and the fumes from gasoline are explosive. It surprises you. I watch that. That's why the guys that have to light bonfires, that clear land for building and stuff like that, and have to burn some of the debris. They do not use gasoline to start it. They use diesel. Gasoline is terribly, terribly dangerous. They use diesel instead. Let's see. We're actually trending about 3% heavier on the guilty side now, up to 87% on the poll for guilty. Yeah, old engine oil, something like that. Learned about the fumes burning first, not the gas. Did not know that. Yeah, the liquid itself is not burning. It's the flammable off-gassed fume portion that burns. And as it heats up, it off-gasses more. So, crazy. Mackie and Me says, I'm in the minority, but the state didn't tell me how she definitively did it. I don't think they need to, though. I think use with circumstantial evidence and the rule that the judge is going to tell the jury about there's as to circumstantial evidence. I think they can consider the other facts surrounding it and make a conclusion based on that without a problem. Is Mrs. R.A. in the house? Oh, have you eaten today? No. Asking for a friend. Who would that be? I'm super hungry, Mrs. R.A. Super hungry. I'm looking at my DoorDash. I've not eaten, nor did I get a break. I had a little break, but I didn't get off my chair. We told him to DoorDash, but I didn't. Katie Bug says we're ordering Chinese. Sounds yummy. I'm just waste. I've got a while before I waste away. I need a little more of my waste to go away. That's for sure. Any verdict yet? No, they have not started deliberation. Karen Reed update. 16 jurors selected. They want a total of 18. The process will continue on Monday. Hey, you come in and you're not. Have you eaten today?
I ate. It was good.
What did you eat?
I had leftovers.
Leftovers? Are there any leftovers? You have a question?
Okay, I have a question. Well, I have a lot of questions. I only watched a little bit of the closing, but his emphasis on do the right thing, hold the government's feet to the fire, really struck me as incongruous with what the whole thing is about. I thought, why is he saying that? Is he reading his jury and saying, this is my best argument, that it's the government who's trying to get you? If you vote not guilty, or I'm sorry, if you vote guilty, the government won?
I think he's looking at a particular juror. I think he has a juror who has like an inherent distrust of the government. At least I'm not sure if it came out in Vordaer or something, but he feels they have a juror who thinks stick it to the man is sort of like the motif. And And I think he's trying to talk to that one juror. Don't let them bully you out of it.
Yeah, there was a lot of that.
Stick to it. If you got the reasonable doubt, this is it. You're done. Don't do any more. I think they're trying to get a holdout juror. We're back. Has anyone seen our client?
Breakfast of Champions.
There she is. You guys get food?
A snack bar? Snack bar?
How that taste, Judge? Yeah. How that taste?
Jay says, yeah. Straightening up the plate. Okay, we're back on the record. Any matters to address before we bring the jury in for rebuttal?
No, Your Honor.
Mr. Mueller or Mr.
No,
Kelly?
Your Honor,
Okay, we'll bring in the jury.
All right. Rebuttal from the state. I think we're going to get jury instructions tomorrow at this rate. It's crazy. We're bringing in the jury right now. Who do you think is going to give the closing, the rebuttal? Do you think it's going to be the same? Mueller? I'd be surprised if rebuttal's more than half an hour. Big guy.
Okay, welcome back, jury. Ms. Ayden, any rebuttal?
Thank you, Your Honor. I'm not going to address 2.5 hours of rebuttal. But I can't get up here and not talk to you about the misstatement of the law that was made by defense. First of all, judge is going to tell you you may not let sympathy, bias, or prejudice influence your decision in any way. That means sympathy for anyone, sympathy for the boys, sympathy for Sandy Stermer, sympathy for Ms. Stermer. It doesn't matter. That's not your job. Your job is to find out if the evidence presented checks the boxes and the elements are met. And sympathy does not play a role. I also want to talk to you about reasonable doubt. We have stated it over and over and over. And every crime is made up of parts called elements. Prosecutor must prove each element of the crime beyond a reasonable doubt. Defendant is not required to prove her innocence or do anything. If you find the prosecutor has not proven any element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not imaginary or a possible doubt, but a doubt based on common sense and reason. A reasonable doubt is just that. A doubt that is reasonable after a careful and considered examination of the facts and circumstances. All his charts and going over the different types of burdens of proof doesn't change your burden of proof. It is based on common sense. It's not imaginary. It's not possible. but it's based on common sense. So get back grounded with what the judge is going to give you. He made several statements, I'm going to reference them as I just go through quickly, that all you got to do is just find one thing and you're done, your job's done. No, ladies and gentlemen, that's why we presented all of the evidence. Your job is to take all the evidence, all the pieces of evidence. If you were to take out the fire inspectors, and we just brought in Dardita Gordon that said she cracked him over the head with an object, you found lacerations, you saw the blood on the van, you found the gas on the sweatpants. If you believe that testimony, you could find her guilty. So each individual person that comes into you is but one piece of evidence. Mr. Trinkle is one piece of evidence. Scott Leroy is one piece of evidence. Your job is to evaluate all the evidence. All the evidence.
Judge has a message on her phone. It's flashing red.
Mr. Leroy didn't do anything wrong. He didn't ruin, I see your face. He didn't do anything wrong by investigating this crime. He wasn't trying to destroy anyone's life.
I see your face.
He's just trying to investigate a crime. He got up there. He honestly told you, you know what? I do things differently today. I should have taken more pictures. I should have done more. He's one piece of evidence. But the interesting part about that is that you can still look at all the other evidence to corroborate some of the things he found. And that's what you need to do. You need to look at. Mr. Trinkle didn't even say that there was a different place of origin other than in the living room. Mr. Trinkle was then wanting you to pinpoint a very specific place of the living room and said if you can't pick that one little spot in the living room, you can't even declare it an arson, ignoring all of the other pieces of evidence that you guys have been presented. The witnesses that were attacked, what you can also do is you can look at the witness testimonies corroborated by other witnesses. So when you have one witness saying something, and it's corroborated by another witness, and it's corroborated by another witness, that may start to make you feel that that information is credible. Kate Fox identified Chris Williams, told the police about where he lived. They went there and he said, yeah, he's having an affair with her. It's corroborated by more than just one person. Even Tina Benny corroborated that there were photos at the scene. You can look at that to say maybe what Kathy Ogwa said is corroborated by somebody else in determining your credibility and the credibility of the witnesses. That's your job. Your job is to determine the credibility of the witnesses. The boys explained their inconsistencies. They told you this is really the first time, it is the first time that they've been able to come in and testify under oath. They explain those inconsistencies. And you can take that and you can weigh that in terms of judging their credibility. It's you that decides the evidence. If it were just, we have an arson or suspected fire and we hire an arson investigator and he says it's undetermined, okay, I guess there's no crime, we can all go home. That is false. That is false. This is an entire investigation. This is an entire investigation. Even Mr. Trinkle told you this is not a legal determination. That's why you're here. He is one piece of evidence that you can consider. Just one. All the evidence that we presented ties to Linda's intent. Her actions support murder. Her actions support premeditation. These are things that are supplied to you to be able to determine if those boxes are checked. You're not simply here as a battle of the experts. That's not what your job is. That's not what your job is. Your job is to evaluate all of the evidence. His expert, Mr. Trinkle, told you, well, first of all, he denied that if he'd ever been involved in a prosecution where there was an undetermined fire. So basically, if the arsonist is so good that everything's burned up, you can't prosecute? That makes no sense. That makes no sense because you're not even looking at any of the surrounding facts. He said he was never involved in a prosecution where it was an undetermined cause, on a fire. And then when Attorney Blair said, well, what about people versus in this very courtroom? And did you see his demeanor change? Because he got caught and didn't know how to answer it. And then basically said, oh, well, I've never been involved in the prosecution where my opinion's been wrong. Because I'm never wrong. He is one expert that you can judge his credibility and his findings. I never asked you for a pass. I asked you to hold me to my burden. And I told you that I wasn't going to bring in 200 people, anybody who'd been talked to, but I was going to bring you in enough evidence to prove the crime, enough evidence to check those boxes. I never asked you for a pass. I'm not asking you for a pass today. I'm asking you to take the evidence that you got from me, from this trial, from those witnesses that took the stand, in totality, and make your decision. There's no pass here. Like I said, you can completely rely on the witnesses that you believe. So if you believe Dardita, you believe the person who analyzed for the gas, you believe the person who then found the blood stains under the car, you've got enough evidence right there to make your decision. You determine who's credible. You determine what evidence is credible, and if that meets the elements. He stated, if there's one reasonable doubt, your job's done. You can all go home. No, I wish it was that easy. You have to consider everything and all the evidence. One reasonable doubt and you're done. That's a misstatement of the law.
It's a misstatement. It's absolutely the law.
I'll give these are closing arguments or arguments of counsel, but I'll give you the instruction on reasonable doubt jury when you go to the jury room, or before you go to the jury room.
If you have reasonable doubt about an element being proven, that's the law. Not if you just have one reasonable doubt about a particular testimony, particular witness. I wish it was that easy. You're not done. Your job is to evaluate all the testimony and all the evidence. He brought up that Linda was in the laundry room. She can't be her. She's downstairs. We talked about that. We talked about how the vapors could have ignited. We talked about a possibility of where that could happen. But you're also then relying on Linda's statements that she was even in the laundry room. A person who only says statements that don't incriminate her. So you can certainly consider that. You can certainly consider her credibility with everything else and all her descriptions, and whether you believe her or not. Counsel's asking you to rely solely on Mr. Trinkle. Asking you to forget that you're the jurors, you're the judge of all the evidence. No one person determines the verdict. And I mean by that, I mean no one witness. It's taken as a whole, and what you feel elements are met. Possibilities. Said you can't consider possibilities. Well, you can consider possibilities if they're backed up by other evidence. You consider the possibility that that gasoline was purchased by her because it's backed up that she bought it. You can consider the possibility that the 1 gallon gas can was used by her because it's a possibility, it's on scene. And you can consider it a possibility because there's no other reason that gasoline should have been on Todd Stermer. You have other evidence that talks about all the other clothing that Matheny had put on him did not test positive for gasoline. You have evidence that that duck boat never ever had an engine. You can use other evidence to make your determinations. And what would then lead towards a conclusion? You consider everything. He wants you to believe that Steve Leach came in and relied on Scott Leroy's report, and voila, there was gasoline, and so he smelled it. Well, you have other evidence supporting that there's gasoline on the clothes. You can consider that. Ladies and gentlemen, they lived in this house for 3 years. It took a long time to build, but they lived there for almost 3 years. No reported issues, no reported fires. And in the documents that you received on the building from the building inspector, there's several written letters by Linda of why they're asking for delays before they moved in. And they detail out Todd Stermer's knee injuries. It wasn't that they were saving up and trying to, put in the cheapest materials or buy as they go. Read her letters. The ones to the building inspector are in there. They're her detailing out how Todd hurt himself. And they had to take a break, and then they needed to restart. Either Miss Stermer is the most unlucky person in the entire world, or all these dots that he talks about lead to the next dot, and lead to the next dot, and lead to the next dot, and show that this is more than just an unfortunate, unlucky series of events. There's been lots of testimony that Linda Stermer becomes overly emotional, only shows emotion when she's pressed. She can turn on the emotion to avoid the questions. Connie is very emotional in that 911 call. What you may be hearing from Linda is that she's scared she just got caught. All she's doing is wailing. You don't hear her talking.
She might be trying to cover up any sounds.
She might be horrified at her own actions. Might not have expected everything to go on the way she wanted. Certainly been enough testimony for you to consider. She might be trying to cover her own tracks. Maybe doesn't want to talk to anybody, wants to play the part. She didn't hide baseball cards, wedding ring, gun. All that can be replaced. Well, it didn't mean anything to her. There was a little bit of mistestimony or misstatement. Ms. Fox said that she wanted to go to the house to find the cup because Ms. Stermer had put something in there. I think she said a tranquilizer. You can check your notes. But changed her mind. And she didn't want the police to find it. That's why you didn't find it in the toxicology. I doubt that Kate knew what the toxicology was when she made that statement. Kim Thompson got to that scene and looked at Ken while she was on scene, and she said, something isn't right. Something isn't right. She didn't need to talk to anybody else to figure that out, that something wasn't right. And then as all the pieces of evidence come in, gasoline on his underwear, gasoline on his socks, yeah, you're darn right, something's not right. Miss Stermer, he said, is either the greatest actress or is genuine. Maybe she just got caught. Maybe she didn't expect to have to try to kill him 3 times before it was completed. And that's what caught her off guard, got her upset, and caused her to act the way she did. Mr. Leroy was also a detective. He was a sergeant with the Michigan State Police. He also then approached this for looking at the evidence that he found. This is why he collected the gas can. No matter how hard you try, ladies and gentlemen, you cannot explain the gasoline on Todd's pants, his underwear, and his socks. Mr. Leroy, Sergeant Leroy, also testified that he worked with the insurance company, got all their documents. They talked about a form that they filed with the insurance company. He had access to all their documents. He reviewed all those documents, and when asked by Attorney Blair if he would change any of his opinions after reviewing all those documents, his answer was no. He had access to Mr. Willison, to Mr. Shinsky, and Greg Stornzan's, any of their documentation, any of their pictures, any of their information. He had it all. You, as jurors, can look at those pictures and see if that area of origin makes sense. You can evaluate that with Linda's statement. You can make those determinations. Now, you can use the expert's advice, opinions, because that's what they are, is opinions, to help you make those determinations when you're going through those pictures. But you can look at that evidence as well and say, does it make sense? He wanted you to focus on the fact that you just can't find there's a source, didn't know how the gasoline gets there, but consider it when determining it in his data. And so because he can't say that the gasoline got there a certain way, then you must rule it out. No, you can still consider it in your data. You can still consider it as part of this. I think Mr. Trinkle and Mr. Leroy both agreed that the ignition source could have been the fireplace. A lot of talk about not ever finding what the ignition source was. I believe both of them testified that that was an open flame in that room and was the ignition source. He wants you to focus on the contamination. However, if you look at the other testimony that's been provided you, that boat's ruled out. And Mr. Matheny's clothing was ruled out through testing.
She didn't testify. Texas brand.
Mr. Z, or Professor Z as he calls him, he can say that he thinks the injuries came from the van, but he couldn't match where or what part. He didn't even say what part could have caused the symmetrical on the either sides of the head. He's not a forensic pathologist. He didn't examine the body. There's a total separate laceration on the back of the head that I questioned him about. I said, you can't even see it in your picture, can you? Because he's laying on it. You can only see the top laceration. He was speculating. He didn't even concern himself with the other injuries on the body and where that blood could have come from. You're also going to get an instruction on credibility and how to judge credibility. One thing that you can read for yourselves is that the judge is going to tell you you can view how an expert answered questions as a way to try to determine their credibility. Mr. Trinkle didn't answer questions directly. when it implicated his client. He danced around. He was very happy to answer any questions he felt didn't implicate. Yet he also agreed on many points of Scott Leroy's investigation. He also reminded you that his conclusions are always right. But again, he is not the only person to consider in this case. This is not, his opinion is not a legal determination. The defense wants to put all their eggs in one basket. Rely on Trinkle, can't say it's an arson, because ignore all of the other evidence, and if you don't have an arson, you got no crime. That's not what you're here for. You're here to look at premeditated murder, and you're also here to look at the felony murder and all the evidence presented to you. He also went on and on and on about this unfinished living room, yet the boys testified, one said it was 95% done and they were getting ready to paint. He did say there was no carpet. He did say there was no carpet, there were just area rugs. But his testimony was that the walls were finished and they were getting ready to paint. Defense read a little bit of the testimony from Dr. Markey, just the sentences that fit his narrative. But look at his report, look at your notes. And when I asked if you can determine if those lacerations came solely from the van, he said, no, I can only say it's blunt force trauma. I said, can you determine if they came before the fire or after fire? He said, no. He said, no. You can only say it's blunt force trauma. And is also in his report, some of those rib fractures were not consistent with CPR. He detailed it out. He detailed it out. Doesn't want you to rely on Dardita because of her medical conditions, yet Dardita had some very, very, I would call it insider information. And when police pressed her, you have her transcript, pressed her and said, is it in a frying pan? She said, no, she just said she hit her with an object. Read that. She knew what Linda had told her. He is correct that Todd Stermer died of thermal injuries. But that doesn't mean you can't consider the fact that she ran him over, jumped on his body. You can still consider all of that, especially with premeditation. He died from the injuries inflicted in that fire. If you find that she intentionally set it, then that's where you go to count 2. And count 2 is the felony murder in the commission or the attempt and the arson. So no arson, no crime? It's not true. You have to weigh all the evidence. You have to weigh all of the evidence, all of the elements, and you need to look at premeditation. You need to look at the attempts, the planning, and all that goes towards premeditation.
That's like a Bob Marley song, right? No woman, no cry.
I'm asking you to make sure you read the law and know why you're here. And you're here to evaluate everything you heard separately. You decide what you want to believe. You decide what's credible. And you decide if, based on what you think is credible, if those elements are checked. That's your job. That's your job. It's not to be narrow-minded. It's not to have tunnel vision. It's to take everything you heard and evaluate it. That's why we brought in the people that we did. Each individual piece is important. No piece is more important than another. no peace. You decide what's important. You are the jurors. You are the ones making the legal decision. I appreciate all your time. Thank you.
And we approach. Objection, she was mean to me. She misstated the law. I take issue with that. He's still making his complaint. State shaking her head. No. Judge shakes her head. No. Okay. I think it was probably had to do with the juror.
I had every intention of reading to you final instructions, but I'm looking at all of you, and you look exhausted. So I'm going to send you home for the evening. And when you come back in the morning, we're going to go right into final instructions. I'll release 3 of you as the alternates and then send you off for deliberations. Okay? Remember the rules. I'm not going to read them all to you again, but absolutely no media observations or talking to anybody. Okay? Thank you.
Let's see here if I can find this part. I want to replay. Oh, I've got the wrong clip. Just one second. Import media. We need this one. Move that one. The part that I think the state just or the defense objected about is right here. Let's see if we can play it. Oh, I can't play it for you. Is it working?
Okay, audience, if you could remain in the courtroom maybe for at least 3 or 4 or 5 minutes here so we can get the jury out, please.
Yes,
to their kindness. You don't have to remain standing, though.
Okay. They are done. They're done if they're letting people go. What's the use of an instant replay? I disconnected it so we could do Brian Koberger because I needed that to be on a separate system so our audio and everything would not be mixed up. And it's still connected to feed separately. But can you hear my audio? This is the weirdest thing. 7, no. You can't hear it. You can't see it. Anyway, I was going to replay. What happened was the state was in their rebuttal. They got up there and they basically opened by saying, Mr. Leroy did nothing wrong. And immediately said, oh, I see your face. He did nothing wrong he didn't try to destroy somebody's life. And when she said, oh, I saw that your face, she's talking to a juror because she's sitting there, and I imagine the juror is watching like this. Okay, it looks like this, right? Juror sitting there listening. She says, Mr. Leroy did nothing wrong. That look of shock, that look of surprise, I'm like, really? And she's like, wait, I see your face. That means that juror believes that the state's fire investigator made a mistake. That juror is a defense juror. That juror is someone who will vote not guilty because I can't trust the state's fire investigator. He didn't do it right. And that, if I were the state, if I were the prosecutor, I'd be worried about. I'd be worried. Everyone's leaving the courtroom. We won't know until tomorrow. The jury cannot deliberate tonight. They have not been read the instructions yet, and that means we have a podcast tonight at 8 o'clock with no verdict interruption this time. So we have the Not Relevant podcast, and you can come and join us and not worry about missing the verdict. By taking a little time out from your day to talk about some of the funnier things that happen in the country and around the world. We'll probably talk about food, especially if I don't get something to eat between now and then. But I might also pass out, Mrs. R.A., if I don't get something to eat between now and then. So Uber Eats is looking really tempting right now. Do you see any grounds for appeal if convicted? Not glaring. I don't think the calling out a juror's face is, her look. I don't think that's appropriate. I think if anything, that hurt the state more than it hurt the defense, because it drew attention to the fact that other jurors who can't see the faces of the people sitting next to them, that one of us strongly believes that the state fire investigator did something wrong. So I don't think that hurts the defense at all. You can think he did something wrong while also believing she's guilty. Yes. But he's the one that came to the conclusion, that it was inconclusive. You see our face. My face is right here. I show you my face. Most of the day I show you my face. All right. I'm excited. Podcast, the rundown is done. Thomas has been working. He's been slaving away. He's been working like crazy today, and he took a break to get the rundown done. We are ready for the podcast tonight. It's going to be awesome. It starts at 8 o'clock tonight. Please join us. The best way, the easiest way to join us on the podcast is to click the subscribe button on the channel if you haven't already. And if you haven't, let me just ask why. Why haven't you? Well, we can talk about that later. And to then ring the bell. Just click to be notified when we go live. Then hopefully at 8 o'clock or shortly thereafter, as the case usually is, when the podcast starts, you will get a little notification on your phone. You can click the button, or you can go on your computer and click the button, and boom, we pop up, and we'll have a little intro music, and it will work perfectly. You'll join, and you'll be there just in time. You'll see all of your friends there in chat that you've got to hang out with all day today, and it's gonna be great. You have 5 reasons. Yeah. Was the prosecution who made their mark? Yes, Judy, it sure was. Sure was. She made the remark, "I see your face," and then she clarified, "That's not a good sign for the prosecution." Carol says, the music, please play the music. It's going right now. Debbie, thanks for the kind words. If that juror is one of the 3 excused, can they call him mistrial? No. And, well, if the judge just dismisses the juror, then maybe. But if the juror is randomly selected and happens to be an alternate, and I think that juror is probably juror number 1, based on where she looked. I don't know. I think there's a high chance that juror is going to be deliberating. All right, 8 p.m. Eastern Time. We've got the podcast tonight. Thank you very much. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again at 8 o'clock tonight with the podcast. Please join us. It's a lot of fun. And all your friends will be there. So Virginia says, what happened with the jury? Virginia, you need to pay attention. I'm just kidding. I'm giving you a hard time, Virginia. I know a lot of people have been watching a bunch of different trials today, and I understand that. So today, in the closing, in the rebuttal, the state said, Mr. Leroy, the fire inspector for the state, did nothing wrong, and there was a face. We don't know what it was. And she said, I see your face. He did nothing wrong he was just trying to do his job. There's one juror that's strongly, at least on that point, with the defense. You guys have a good night. We will talk to you later tonight at 8 p.m. Have fun. Bye-bye.
Because he's the guy.
Sorry, Virginia. I didn't mean to call you out like that. That was mean of me. Please accept my apology.